Hello and welcome to week 2 of business law. And this week we're going to cover chapter 2 called dispute settlement. And we're going to be looking at a number of different things. First of all, let me caution you, this is a fairly lengthy presentation. And I don't want you to get overwhelmed by it. We'll go into some level of detail. I don't really care if you remember all those details. Don't get hung up on how many judges are on a particular court or that kind of thing. I'm just trying to give you an overview of the court system, litigation, how all of this stuff works. If you're in business for any length of time, you will deal with litigation in some way, shape, or form at some point in your career. It's just an unavoidable fact of life. So I'd just like to give you an overview of how the court system works, of how litigation, the process of that works. So you'll have some familiarity with that when you do come across it in your career. If you've had American government, a lot of this will be review, but we'll be covering some things you've probably not heard before as well. So we're going to look at really 3 different things in this lecture here: how the court system works, how it's structured. We're also going to look at the process of litigation. When a lawsuit is filed and it goes through all those stages, clear up to a judgment, we're going to see how that works, and even appeals and that kind of thing. We'll get an overview of that. Also, we're going to look at alternatives to litigation. Increasingly, it's more popular to try to stay out of court altogether for various reasons, and we will look at that as well. Okay, well, refreshing our memories of what governments do. Remember last week we talked about that they create order and stability by creating a legal system. As part of that, there are really 3 main processes that they do, and if you remember the 3 branches of government, these will be very familiar to you. They legislate, which is they create laws, they write statutes, they set down the rules. Also, they execute those rules. It really does us no good if we have rules if there is no one to make sure that people are following the rules and to punish the rule breakers. So we have the executive branch. Remember, the legislative branch is Congress or the state legislature. The executive branch is at the federal level is the president and everyone under him, most of the bureaucracies. The FBI and Justice Department, all those kinds of folks. They are executing the law. We also have to adjudicate, which is to take the rules which the legislature has written, those general principles, and apply them to particular facts. And that's what we're really going to be concentrating on in this unit. And really, you have to take those general principles and apply them in a particular case based upon the facts of that case. We used the example in the last unit of cruel and unusual punishment, and that can mean different things to different people. And how do we know what that is in a particular situation? Well, we have courts that tell us that. They take those general rules, look at the facts of a particular case, and apply those rules to those facts. And that's really what the process of adjudication boils down to. And so that's what we're going to be focusing on in this unit. Let's talk about different types of cases. First of all, there are criminal cases. If you watch shows on TV with cops and prosecutors and law and order, that kind of thing, that's what you see going on, criminal cases. A criminal case is dealing with a wrong against society as a whole. And this is a little confusing because we know with crimes, there are victims of crimes. If Bob goes and shoots Sally and kills her, Sally is a victim of the crime. You think, well, that's a wrong against Sally. Well, yes, it is. But when we're sending that person to prison for murder, we are punishing the wrong against society. This is the government exercising its authority, fulfilling its responsibility to bring predictability and order to society. If we let the Bobs of the world go around shooting the Sallys of the world, then we would have chaos. We can't have that. And so a criminal case is all about punishing that wrong against society to maintain that order and that predictability. So we don't have chaos, so we can build businesses and hire people and go to school and do all those normal kinds of civilized activities without worrying about a Bob coming around and shooting us. So that's what criminal law is. We'll look at crimes in one unit as we go along, because that does, unfortunately, have something to do with the world of business. But we'll be focusing the vast majority of our attention on the second kind of case, and that is civil cases. A civil case is really a private dispute between companies or individuals or that sort of thing. And this doesn't involve a wrong against society. It may be a wrong against you personally, but not as society as a whole. If you've breached your contract, we don't think that's a wrong against society. That's something for you to work out with you and the other parties to that contract. And so that's what we mainly will be focusing on. What can get kind of confusing is that one incident may give rise to both civil and criminal cases. Let's say that instead of just going out and shooting Sally, that Bob is drunk driving. And so he runs a red light and smashes into Sally's car and kills her. Okay, we have two things going on here. First of all, there is a criminal case. There is drunk driving, maybe negligent homicide. Those are crimes. That's disorder that must be punished by the government to make sure that we have that civilized environment. However, Sally's surviving family may sue Bob for wrongful death. That's a civil case because they have been wronged personally. They've lost something, and they may get money damages based upon that case. So that's one set of facts that can give rise to both a civil and a criminal case. So Bob may go to prison for the criminal in the criminal case, but for the civil case, he may have to pay a bunch of money. So the same set of facts can give rise to both a civil and a criminal case. And again, we'll mostly be dealing with civil law. So we'll mention criminal some, but most of the time when we're talking about business law stuff, we're talking about civil law. Okay, well, let's talk about courts and jurisdiction. And this can get a little thick, and we'll see why, because first of all, in the United States, we don't have one court system, we have 51 court systems, or maybe more if you throw in Puerto Rico and Guam or whatever. But every state has its own court system that handles its own cases within that state. We also have a federal court system set up by the national government in Washington, D.C. And the interplay between those two layers of courts is kind of complicated sometimes, and we'll kind of look at that. And we have a huge body of law existing to tell us which system to use for which kind of case. And so it's the first thing as a lawyer you have to do when a case comes in is figure out, okay, I've got to file this case. What court do I go to? You wouldn't think that's a big problem probably if you haven't dealt with it before, but it can get kind of complicated, and we'll get a feel for that throughout this unit. And well, there are many different kinds of jurisdiction. We'll look at that in detail in a little bit. But first of all, a court may have what's called original jurisdiction. That's the first court that hears a case. So when you file a lawsuit against someone, you end up in a particular court. That court has original jurisdiction. And so they're the ones that are doing the bulk of the work on the case. They're going to be hearing the evidence. They're going to make rulings of law, as we'll see, doing all that kind of stuff. And so they have what's called original jurisdiction because they're the original court to hear the case. Some courts have appellate jurisdiction, and they will look at cases heard by the first court and decide if a mistake was made or not when the case goes up on appeal. So we'll look at that as well. Some courts may have no jurisdiction in a case and not be able to hear it at all. If you get into a car wreck with if you're a Missouri resident and the other driver is a Missouri resident, you have an accident in downtown Neosho, and you go try to sue this person in the state courts of Alaska. The court in Alaska most likely has no jurisdiction at all, has nothing to do with this case. They will dismiss it. They will just kick it out and say, sorry, we have no power to hear this case. And so, if you file a case in the wrong court, may not be the end of the world, but they will kick it out. You'll have to go find a different court to hear it in. So it is important to kind of understand the outlines of the rules of jurisdiction. Let's talk now a little bit more about original jurisdiction. In most cases, we'll start in the lowest court in a court system, otherwise known as the trial court. The case will actually be filed there. When you sue someone, you have to create a document. We'll talk a little bit more about it later, called a petition in Missouri. Most jurisdictions call it a complaint. But you file this thing saying, hey, Bob broke my contract. I'm suing Bob. Here's why I want all this money. So that document gets filed somewhere. It'll be in the trial court. And then you'll do discovery, and you'll maybe have a trial, and all that takes place in this lowest court in the court system, the trial court. Discovery will take place there, and we'll look at that again more in detail later. That's where you just find out the facts of the case. You'll ask the other parties questions. You'll take depositions and stuff, and we'll see what tools are available there a little bit later. There will be motions that are filed and ruled upon. There may be motions to exclude particular types of evidence or something like that. There may be motions to kick the case out completely. But that'll be taking place there. That trial court judge will be ruling on these motions. Then if we get to that point, the case will be tried before a judge and perhaps a jury. Depends in a civil case. It may not be a jury, but there may be. And they'll hear all the facts and try to figure out what the facts of the case really are, and then there will be a judgment entered, and the case will reach a final judgment. And sometimes, a lot of cases will settle actually before they get to this point, but if we get this far, we'll have a final judgment in the trial court, and we can't appeal that perhaps. Most cases never are. They end right here in the trial court. Probably, 90% of cases are never appealed, and they just stop right here. So that's the trial court. Let's look a little more in detail about what the trial court actually does. A couple of different tasks are before the court. One is to make a finding of fact. If there is a dispute on, what actually happened in a case, let's use our old car wreck case again. Let's say that we have two cars that are at an intersection and they collide in the middle of the intersection. Well, one person is going to be saying the light was red, and the other person is going to be saying, no, the light was green. And so anyway, we'll have to figure out what the facts actually are. That's a finding of fact. And if there is a jury, the jury will be making those findings. They will hear all the evidence. They will listen to the witnesses, try to figure out who's lying and who's telling the truth. And they'll try to put all that together and figure this out and make a finding of fact. If we don't have a jury, if it's a judge-tried case, then the judge will make the findings of fact. But if it's a jury, the jury is the one who does this. We'll also have to make rulings of law. And this is always done by the judge. But in this particular case, we'll be, in this situation, we'll be looking at how the rule of law actually applies in this particular case. In my example here, let's say in our car wreck case, the defendant had several DWIs over the past 10 years. Okay, well, there'll be an argument over whether that can come into evidence or not. And the rules of evidence are rules of law. And so the judge will be deciding in this particular case, does this evidence ever get before the jury or not? So that's a ruling of law, trying to figure out, procedurally how the case is going to proceed, what evidence can come in, that sort of thing. And again, this is always made by the judge. The jury never makes rulings of law. That's always the judge's job. Appeals happen, usually at least, when one side argues that the trial court made a mistake, an error is what it's called, in a ruling of law. When we appeal a case, we won't normally be arguing, the jury screwed up figuring out that the light was red when it was really green. We're not going to be arguing about findings of fact. We'll be arguing about rulings of law. So let's say that the judge lets in all those previous DWIs. When on appeal, the defendant's lawyer will say, those should never have come into evidence. That was a mistake in ruling of law. And so that's normally the kind of thing we'll be arguing about if the case does go up on appeal. So let's say that we had our car wreck case and the defendant lost, had to pay a bunch of money, or at least that was the judgment of the trial court. And the case is over as far as the trial court is concerned. A final judgment's been entered. Well, in that particular situation, the case is what's known as ripe for an appeal. And so if the defendant is still unhappy, they can file what's called a notice of appeal, telling the plaintiff, you think you won, but I'm not done yet. I'm going to the next layer of courts. And what the appellate court does is review the case to see if there was a mistake. And usually, in I think every jurisdiction I know of, in the United States, there is a middle layer of courts above the trial court before you get to the top layer, which is the Court of Appeals. And they will hear these appeals. Again, usually they will only review the rulings of law. They won't, retry the evidence and try to figure out who was telling the truth. They'll just look at what the trial court judge decided and see if he made a mistake according to the law. They will look at the record on appeal, which are the transcripts of what happened in the trial court. They'll look at all the evidence that was entered. They'll look at all the pleadings and motions and things that were filed. It's all a bunch of paper. So they're just going to be looking at this case, the record of this case, and see what happened and try to figure out if the trial court made a mistake or not on a ruling of law. The different parties will file what's called a brief, where they will put their arguments in writing, and then once that's been filed and the appellate court judges have a chance to look at that, there will be oral arguments. and the attorneys will get up there and try to convince the appellate court that their side is right, and argue the case that way. So that's what an appeal really consists of. And there are a few different things that the appellate court can actually do. They can agree with the side who appealed the case and say, ooh, well, look at that. The trial court made a mistake, and they will reverse the case. So when they reverse the case, they are disagreeing with the trial court judge, saying that a mistake was in fact made, and kicking it back down to the trial court and saying, clean up your mess and go the other direction. They can agree with the side who didn't appeal and say, no, the trial court didn't make a mistake. They, in fact, made the right decision. And so then in that case, they are affirming what the trial court did. So if they agree with the trial court, they have affirmed its decision. Then, whether they reverse or affirm, they will usually send the case back to the trial court with instructions, and that's called a remand. So they will remand the case back to the trial court saying, okay, trial court, this is what you did right, this is what you did wrong, here's what you need to do now, go take care of it. And that's a remand. So that's what happens after an appeal. If the parties are still not happy, they can ask the highest, usually the Supreme Court in the jurisdiction, to take a look at it. And that's what we'll look at next. Every jurisdiction has some kind of top dog court that is the final say. In Missouri, we have the Supreme Court of Missouri. In the United States, we have the United States Supreme Court. The funny thing is, you usually have no right to have your case heard by the Supreme Court. The Supreme Court in a state or the United States can pick and choose what cases that they actually hear. Kind of funny, you think that, but just stop and think for a minute about, we only have one court here. How many cases are filed every year? If they had to hear every one that somebody wanted them to hear, they would be overwhelmed. And so what they do is they pick and choose what they think are the most important cases, or where there's an actual legitimate dispute that needs to be straightened out because the law is not clear on something. And so they get to pick and choose what cases they hear. So just because you want to appeal to the Supreme Court doesn't mean they'll actually take the case. And so even if you take a case up on appeal, most of them end right there. So the Supreme Court, of all the cases that are filed, maybe hears 0.1% or something of all the cases that are filed. Very few actually make it there. And again, they can affirm the appellate court. They can reverse and remand. Same type of thing. It's the same system. They have briefs, and you go make oral arguments, and then they will look at the trial court, and try to figure out, did the appellate court get it right or not? And then again, they will send it back to the trial court. And they are normally the last word. If you get to the Missouri Supreme Court, they have the last word on what Missouri law is. If you get to the United States Supreme Court, they have the last word on what federal law is, or what the U.S. Constitution says. So once you get there and they speak on it, that's it. There's no place else to go. What they say is the law, and that's why we say that they are the court of last resort. They have the final say in defining what the law actually is. Well, here I have a little chart for you, kind of comparing the federal system with the Missouri system. And you can see that there are a lot of similarities. I'm not going to make you memorize all of this information, so please don't worry about committing this to your photographic memory. I just want to give you a little bit of an idea of how the different court systems are structured. There are all a lot of similarities between different states and the federal government as well. In this system, we'll look at the federal system first. We have the trial courts. Those are called United States Federal District Courts. There are 94 districts total in the United States. In Missouri, we have 2, the Western District based in Kansas City, the Eastern District based in St. Louis. There is a federal court office in Springfield. It even hears cases in Joplin some of the time, but the court is actually based out of Kansas City. That's the Western District. And so you'll have, in every state, there's at least one federal district court, more depending on the population, the caseload in that particular jurisdiction. And so that's where federal cases start, as the federal district courts. If they are appealed, then they end up in the circuit court of appeals. And there are a number of different circuits. We'll look at that. I have a nice little map coming up shortly. I see that there's a map reference here to page 30 and 31. That's actually the old textbook that I used to use for this class, so you can kind of ignore that, but sorry about that. But anyway, those are 3 judge panels that hear cases. And they will cover many different states usually. There are only 11 circuits in the entire United States, and so they'll cover many different cases, as we'll see. And then we have the United States Supreme Court at the top, a panel of 9 justices. We don't call them judges. They're more important than that. We call them justices. And they have appellate jurisdiction. Oddly enough, I won't, you don't have to remember this, but they have original jurisdiction in rare cases, such as when one state sues another state, like if Missouri is griping at Iowa for taking too much water out of the Missouri River. Missouri sues Iowa. That goes straight to the U.S. Supreme Court. Normally, though, they're just hearing appeals that are coming up from lower courts that have already been. They started out in the U.S. District Court, got to the Court of Appeals, one of the different circuits, and then they'll end up in the United States Supreme Court. In Missouri, the system is very much parallel in structure. We have circuit courts in Missouri, and those are the courts of original jurisdiction over most cases. And each county has a courthouse, but they may not have their own circuit. It depends on the population. For instance, Newton and McDonald counties are in one circuit, the 40th Circuit, and they share a population of judges who some days will have court in Neosho and some days will have court in Pineville, and they'll go back and forth. Jasper County is a larger county. It's its own circuit and actually has 2 courthouses, one in Joplin, one in Carthage. And Jasper County by itself is the 29th Circuit. And the reason we call it a circuit is because in the olden days, we had judges who would get on a horse and they would go from one county to the next hearing cases. And so they would ride the circuit. But we still use that terminology today. But again, and for instance, some circuits will have multiple counties. Vernon, Barton, Dade, and Cedar, I believe, are one circuit. And so you have the same judges that'll go from one courthouse to the other, go from Nevada to Lamar to Greenfield to Stockton. Hearing cases, and so that's how that is set up. Then the next layer in Missouri is the Missouri Court of Appeals. There are 3 districts in the Court of Appeals of Missouri. There's the Western in Kansas City, the Eastern in St. Louis, and the Southern District in Springfield. Jasper and Newton counties and most other counties around here are in the Southern District. I think Vernon County and North are in the Western District. And they will hear appeals from the circuit courts that happen to be located in their district. And so they will handle the appeals out of those circuits or those counties. And then we have the Supreme Court of Missouri in Jefferson City, a panel of 7 justices. Again, they'll have original jurisdiction in rare cases, but for the most part, they're taking cases that are on appeal. And so if they take a case, it's probably already been through the Court of Appeals, and they can agree with what the Court of Appeals said or not, or reverse, affirm, all that kind of stuff. So as you can see, parallel systems, most systems are set up this way in pretty much every state. Only a few weirdos. New York is a weirdo. Cases start out in the Supreme Court, which is the trial court, which makes no sense to me, and ends up at the Court of Appeals, which is the highest court. So they have it completely backwards, but it's New York, so I guess what do you expect? So anyway, this is kind of an overview of how the different systems are set up. Let's look more closely now at the federal court system. Probably the most surprising thing that people learn about the federal court system is that it has limited jurisdiction. That means that it can't hear just any case that it wants to, and we'll look in a little more detail later about the types of cases it can hear. But the bulk of cases in the United States, I don't know what the percentage is, but the vast majority are heard in a state court because you have to be special to get into federal court in one way or another, and most cases aren't special. So kind of interesting. For the most part, state courts are doing the bulk of the work in the United States, and only a few cases are heard in the federal court system. And it's important to remember, too, that the federal courts really aren't more important than the state courts most of the time anyway. They can't overrule a state court if they want to. They just hear different kinds of cases. And so the Missouri courts, have the final word on Missouri law most of the time. The federal courts have the final word on federal law. And, it's 2 parallel systems, but one's not more important than the other. We need them both. Anyway, and so not every kind of case can be heard by a federal court. It has to be special. We'll look at what special actually means a little bit later. And to be special means they have subject matter jurisdiction. That means that the type of case is a case that can be heard by the federal court. And not every kind of case can be heard by a federal court. They have to have jurisdiction over the subject matter of the case, what the case is actually dealing with, be it a car wreck, a contract, a criminal case, whatever. The court must have jurisdiction over that subject matter. They also have to have jurisdiction over the parties to the case. And we'll look at this in more detail later, but in order for the court to be effective, they have to have some power over the people who are in the lawsuit. They can't order someone around who may be completely out of the jurisdiction unless they have contacts with that jurisdiction. We'll look more about that in detail. But just for now, keep in mind you have to have both subject matter and personal jurisdiction. And again, the federal courts are limited by Congress. The Constitution, Article 3, sets up the judiciary branch, but it only really says anything specific about one court, and that's the Supreme Court, and then left it to Congress to set up everything else. And so Congress has created the courts of appeal in the federal system as well as the federal district courts. And Congress has also made the rules about what the different cases are that the courts can hear in the federal system. And not every case is one that the federal courts can hear. And again, we'll look at that in more detail shortly. Again, and we just looked at this chart, but to remind you, there are 3 levels in the federal court system. There are district courts where cases usually start. If they're appealed, they go to the Court of Appeals in whatever circuit the district court happens to be in, and then the United States Supreme Court is at the top. This map just kind of gives you an idea of how this is set up in the state of Missouri. The gray counties there are all in the Western District in Missouri. That's the federal district court for the Western District of Missouri. It covers those gray counties. And then the ones that have little numbers in them that aren't grayed out, those counties are in the Eastern District. And so the federal district court for the Eastern District of Missouri hears cases coming out of those counties. And so most states have a map like this. Again, each state will have at least one federal district court. Many will have more than one, depending on the population and the caseload coming out of there. This is a view of how the federal courts of appeal are set up, and they are set up in circuits. The 8th Circuit is the one that Missouri is in, and you'll see that it includes federal district courts in several different states. The Dakotas, Nebraska, Minnesota, Iowa, Missouri, and Arkansas are all in the 8th Circuit. And so if you have a case that comes out of one of those district courts, that will end up, if it's appealed, in the 8th Circuit Court of Appeals, which is headquartered in St. Louis. And so that's where cases will come from there. You can see the 10th Circuit includes the states of Oklahoma, Kansas, Colorado, New Mexico, Wyoming, and Utah. The 9th Circuit has the whole West Coast. They're known as the most liberal circuit. They're on the left coast. And different circuits going to have different personalities, I guess you could say, and the types of opinions that they tend to render. But you can see how it's set up. There are only 11 circuits to cover the entire United States that handle that middle level of appeals. All right, moving on the federal court system. We have the United States Supreme Court, which is the top dog. That's based upon in Washington. Has 9 justices on it, which are appointed for life and confirmed by the Senate. They're appointed by the president, then the Senate has to vote and approve them. And then once that happens, they are there for life, unless they decide to retire, resign, or get impeached if they do something really wrong. That's never happened. But anyway, they're appointed for life. That may seem kind of strange in our democratic system. We appoint someone for life. They never have to get reappointed. They never have to stand for election. That doesn't sound very democratic. Why do we do that? Well, the Founding Fathers designed the Supreme Court to be the conscience of the government. They wanted the justices to be completely free of external influences and political pressure. If the justices had to stand for election, if they had to be reappointed, there would be a pressure on them to do things that were popular. And sometimes the right thing to do isn't the popular thing to do. And so they wanted them to be completely free of any of that outside influence and just to concentrate on what the law is, what's right, what's wrong, and not have to worry about any of that other stuff and their job security. So that's why they're appointed for life. We already mentioned they get to pick and choose the cases that they hear. A case will start out in a federal district court and let's say get to the 8th Circuit Court of Appeals and one of the parties is still unhappy. One of those parties will apply for a writ of certiorari, is what this is called, to the Supreme Court. And that's just a fancy Latin term. It's an order that says, send the case to us. And so they'll petition for a writ of certiorari to the Supreme Court. The justices will look at the case, and if a certain number of them think, oh, this case is worth hearing, they will send that writ of certiorari down to the Court of Appeals saying, okay, guys, stop working on the case, send it to us, we're going to deal with it. And then they will hear the case. And whatever they decide is it, normally. So that's how that works. They get to pick and choose which cases that they're going to hear. How do they choose which cases to hear? Well, usually one of two different reasons is why they'll be picking a case. One is it deals with a very important constitutional issue, some basic understanding. The most recent case that comes to mind is the whole gay marriage case. That was a very important basic constitutional issue, so they wanted to deal with it. Or they can have a case where different circuits disagree. So let's say the Eighth Circuit says one thing and the Ninth Circuit says something else. Suddenly we have a disagreement. Half the district courts say one thing, half the district courts say something else. We want to resolve that because we need that predictability and certainty. And so we'll want to resolve that. And so the Supreme Court will weigh in and say, nope, half the circuits are wrong, the other half the circuits are right. This is what we need to do going forward, and they will get that straightened out. So that's how they pick that. And once the court hears a case, there will be briefs, there will be oral arguments, just like any other court of appeals. Then they will vote on it, and it takes a simple majority of the justices to reverse a case. Once in a while, you'll have a tie. You might wonder, with 9 justices, how do we have a tie? Well, sometimes one of them will have to recuse themselves. Let's say that one of the justices has a daughter who's employed as a CEO of Walmart, and the case involves Walmart. Well, they can't hear the case. Their daughter is involved. So they have to recuse themselves. And so they won't hear the case. And so then we have 8 justices. Well, a 4-4 tie means that the case will be affirmed because it takes a simple majority to reverse. And so out of that 8, you would still need 5 of the 8 in order to reverse the case. And so the justices will take a vote and decide, what they think about it. And what the majority of justices decide becomes the law. And they write the majority opinion, which sets forth how the law applies in this particular case, and that is the law. Okay, let's look more in detail now about the Missouri court system. We already mentioned that the federal courts only hear special kinds of cases, which again we'll talk about shortly. State courts handle everything else, so the bulk of the cases in the country, probably at least 3/4, are heard by state courts, and they do most of the work. Again, we had the Missouri Supreme Court as the top dog defining what Missouri law is. Normally, no other court can overrule the Missouri Supreme Court on defining Missouri law, not even the U.S. Supreme Court. The only time that the Supreme Court of the United States would weigh in is if Missouri is doing something unconstitutional, something that conflicts with federal law. But if it's just dealing with Missouri law, the Missouri Supreme Court has the final say. Again, we already saw in that little chart, the Missouri Court of Appeals has 3 districts, Western, Eastern, and Southern. The Southern is based in Springfield, that handle the different kinds of appeals. And then we have the circuit courts, 1 or more counties per circuit throughout the state, and they do probably 98% of the work. That's where the cases are filed. That's where the trials are held. They do most of that. Probably 5% of cases ever end up on appeal, maybe less. Then the Court of Appeals handles those, and very few of those ever get to the Supreme Court. So the bulk of the work is done by the circuit courts, which are the trial courts in the state system. Interestingly enough, we just talked about how the U.S. Supreme Court justices are chosen. We don't want them to be free of external influence and stuff. In Missouri, we don't care so much about that, apparently, because our circuit judges are elected. They will actually stand for election, just like your county sheriff or your county dog catcher or whatever. It's an elected office. They all run for office as a Republican or a Democrat or whatever in most places in the state of Missouri. And, you can kind of see where there might be some issues there. If they're soliciting campaign contributions or, soliciting votes and they want to get reelected, they'll try, may have a pressure to do what's popular. They're not supposed to. They're supposed to do what's right and not care about what's popular. But you can see where they might, scratch their heads a little bit and think, if I rule this way, am I going to get reelected? And so that's maybe not the best system. And actually, Missouri has changed that in like St. Louis and maybe Kansas City. I can't remember for sure. But the bigger cities trying to get away from that and appoint judges a different way, the same way that the Court of Appeals judges are chosen, and also the justices of the Missouri Supreme Court. And that's by something called the Missouri Plan. If you've had government in the state of Missouri and covered the Missouri Constitution, you may have heard of the Missouri Plan. It's called the Missouri Plan because we invented it, and gosh darn it, we're proud of it. It's really not that different from something you might expect, but it tries to take the whole politics out of the equation when choosing judges. The governor will give some names to a commission who will pick someone to fill that vacancy on the court. And then the people do get a say in it. They'll get a question on the ballot. Once in a while, you may have seen these if you've gone voting recently. They'll say, should Judge so-and-so be retained on the Missouri Supreme Court? And so the people don't get to pick the judges they want. The judges don't get to run for office. But once the judge has been appointed by this independent commission, the people of the state of Missouri get to decide whether they want to keep this person around or not. So it tries to give the people some kind of say, but also insulate the judges from most effects of popular opinion so they can be independent. So anyway, there's your Missouri civics lesson for the day. But anyway, that's how judges are chosen in the Missouri court system. Let's talk more now about jurisdiction. We already mentioned some of these terms already, but I think it's important to understand what allows a court to hear a case. In order for the court to actually decide a case, they have to have jurisdiction. They have to have jurisdiction over the subject matter of the case. And we talked about that briefly already. But let's say your case involves contracts, or your case involves a criminal issue, or whatever. We have to get it into a court that can hear that type of case. And some courts can hear just about any kind of case at all, and those courts have what is called general jurisdiction. And Missouri circuit courts have general jurisdiction. They can hear almost any kind of case that you can think of to bring. There are very few types of cases that they cannot hear. It'd have to be something really weird, like dealing with patent law or something. But almost any type of criminal or civil case could be heard in a Missouri circuit court if the stuff happened in Missouri. So they have very broad jurisdiction. It's called general jurisdiction. Some courts don't have that. They have what is called limited jurisdiction, and federal courts have limited jurisdiction. They can only hear the kinds of cases that Congress says that they can hear. So they can't hear just any old kind of case. The first question to answer if you want to get into federal court is, do I have a federal case? And most cases aren't. So those courts have limited jurisdiction. Some courts have exclusive jurisdiction. They have, you can't bring that kind of case in any other court but this court. That's kind of odd, but you'll see it happen once in a while again with like patent law. There's a system of patent courts that hear patent cases, and that's all they do, and you can't bring a patent case somewhere else. So not that common, but it does happen. Some courts will have concurrent jurisdiction, and this can happen when more than one court would have jurisdiction over the case. There are some cases that you can bring either in federal court or state court. Either court could hear the case, and so those courts have what's called concurrent jurisdiction because either one could deal with the case. Again, federal courts have limited subject matter jurisdiction. They can only hear the kinds of cases that the U.S. Congress allows them to hear. One type of case that they can hear is if it involves a federal question. That is, if we're talking about federal law, the United States Constitution, a United States statute that was passed by Congress and signed by the president, if it involves something like that, then a federal court can hear it. And that's really what they were designed to do, was to deal with questions of federal law. And so if your case involves, you're suing this police department in your city because you think they had an unlawful search and seizure without a warrant or something, that's a Fourth Amendment question. Dealing with the federal Constitution, you could bring that in federal court. But by and large, your ordinary car wreck case or something like that has no federal question. And so it would not be able to get into federal court unless it has something else special with it. Okay, so that's one way you can get into federal court, is if your case involves a federal question, a question of federal law. Another way that you can get into federal court is through diversity jurisdiction. And Congress set up the courts in 1789, and it was a very different country back then. And there was a lot of state bias. If somebody from Massachusetts went down to South Carolina and ended up in a contract dispute, there was a real fear that the South Carolina courts would have some bias against this Yankee that was down there, that sort of thing. And so what Congress did was provide a way for federal courts, which were seen as being more cosmopolitan and fair and not tied to a particular state. They would be more fair in this kind of situation where you had a dispute between citizens of different states. And so Congress created what is called diversity jurisdiction. And diversity in this situation just means that the people in the case, the plaintiff and the defendant, are from different states. They are citizens of different states. And if you have citizenship in different states, that's diversity. So a federal court can hear a case, even if it's an ordinary, run-of-the-mill state law issue like a car wreck. Let's say that somebody drives over to Neosho from Oklahoma, gets into a wreck on the boulevard. Okay, normally that's not a federal question. There's no question of U.S. constitutional law, federal statutes, anything like that. But we might be able to get into federal court anyway based upon diversity, because you have a citizen of Oklahoma and a citizen of Missouri, and it's a state law claim, but they have diverse citizenship. So diverse citizenship is one requirement of diversity jurisdiction. The other is what's called the amount in controversy. And that was kind of keeping the door shut on a lot of these cases that didn't involve a whole lot of money, because we didn't want to burden the federal courts dealing with these silly little state law claims between people in different states unless it was an important case. And the way we define important is by how much money we're talking about. And right now it's $75,000. So if you have diverse citizenship and you're claiming more than $75,000 in your lawsuit, then we have diversity jurisdiction. And then your case can get into federal court, even if it doesn't involve a federal question. If it's just some silly state law claim, then we can get into the federal court system. So those are the two major ways that we can get into federal court. And if we don't have a federal question and we don't have diversity, pretty much you're going to end up in state court. So that's the way that works. I will mention also there's something called supplemental jurisdiction. And let's say that you had a federal question type case. For instance, your case where you're suing the police department for invading your house without a search warrant. That's a Fourth Amendment case. You can get into federal court based on that. But let's say you also have a state law claim against that police department because they ruined your Ming vase when they broke into your house in the middle of the night. Okay, well, that's not necessarily a Fourth Amendment case. You're just suing them for the value of that vase, and you want them to reimburse you for that. That would normally be a state law claim, let's say, just for the sake of argument. And so normally that claim in and of itself wouldn't be able to get you into federal court, but because we have that federal question there and the state law claim arises from the same set of facts, then we'll let the federal court go ahead and decide that claim as well. So anyway, what state law claims that normally wouldn't be able to get into federal court can kind of ride in on the coattails of the federal question once in a while. So anyway, that's what you need to know, that it's kind of unusual to get into federal court. You normally have to have a federal question or a diversity jurisdiction, which means diverse citizenship plus having at least $75,000 in play. So that's how we get into federal court. Okay, well, still talking about jurisdiction, let's move from subject matter jurisdiction to personal jurisdiction. And not only does a court have to have the power to hear the type of case that's before it, but it also has to have the power to enforce a judgment upon the people in the case. Sometimes that might not happen. And we already touched on this example earlier, but let's say that we have a car wreck in Neosho between two Missouri residents, and one of the person that was hit in this wreck tries to sue the other driver in Alaska, okay? And neither of these people have ever been to Alaska before. The driver that was, who may have been at fault here has never been to Alaska. He's never been further north than Lamar. He has nothing to do with Alaska. Is it fair to allow him to be dragged into court in Alaska over something that has nothing at all to do with Alaska? And the answer is no. And the actually, the United States Constitution has something to say about this through the Due Process Clause of the 14th Amendment. The courts have decided it's unfair for someone to be dragged into court in a jurisdiction they have nothing to do with. That jurisdiction should have no power over them. And so we have to also worry about what's called personal jurisdiction. Can that court enforce a claim against the defendant? And not only do we have the constitutional limitation, we also have statutory limitations. Congress has had something to say about this. And you have to have some kind of connection to the state in order to have, or the jurisdiction to have personal jurisdiction in a particular case. And normally, if you have someone who's living in the jurisdiction, we have no problem with personal jurisdiction. If you live and go to work and everything else in the state of Missouri, then a Missouri court or even a federal court located in Missouri is probably going to have personal jurisdiction over you, no problem. That's a no-brainer. Other situations, though, cause us more trouble. And we have to have what's called minimum contacts with the state in order to have be subject to personal jurisdiction of a court in that state. Let's say, for instance, that you run a company that sells widgets and you ship widgets to Missouri and your widget blows up and kills someone. In that case, you have minimum contacts because your widget has gone to Missouri. You shipped it there. Okay, that's pretty much a no-brainer. Let's say that you only ship widgets to Kansas and someone in Kansas buys your widget, takes it across the border to Missouri where it blows up. Can Missouri courts have personal jurisdiction over you then? You never purposefully tried to send your widget to Missouri. It landed in Kansas and you didn't know it went to Missouri and suddenly you're being sued in Missouri. That's a more gray area. And there's no easy answer sometimes to some of those questions. That is the subject of litigation. But anyway, it's interesting cases come out of this. Situations like where there's, a fist fight on an airplane that's flying over a state and it never landed in that state, but somebody gets hurt and sues. Did the state that you were flying over have jurisdiction or not? And sometimes there's kind of interesting cases that come out of this, but it is an issue that you should know about, and you should think about this sometimes if you're working for a company selling widgets. Your widget ends up in Connecticut, you might get sued in Connecticut. They might have personal jurisdiction sometimes. It just depends. But this is really defined not only by the Constitution, also by statute. And states have what are called long-arm statutes that seek to define how much personal jurisdiction they have, what the limits actually are. And Missouri has one of these. Most states do. That usually take it to the limits of the constitutional definition of what's fair. But various different things can get you subject to Missouri jurisdiction. Engaging in commerce, in a paternity suit, having sex in the state of Missouri can get you subject to Missouri courts. All kinds of different situations. So the long-arm statutes actually spell all of that out. We should also point out that personal jurisdiction can be contested. If you get served, by a court in Alaska, or whatever, and you think that that court has no jurisdiction over you, you can contest that. You can do what's called a special appearance, where you will appear in that court for the sole purpose of contesting jurisdiction. And you can argue about that, and if you win, the case will be dismissed, and whoever's suing you will have to file it somewhere else. However, you can waive personal jurisdiction claims. They're not always going to be there. You can, if you decide to show up in court, like, I don't mind court in Alaska. I think that'll be fun. I'm going to go defend my suit in Alaska, and you show up there even though that court shouldn't have anything to do with the case. If you want to go litigate in Alaska, then by golly, you can waive your personal jurisdiction claim and go up there and do it. And sometimes that can happen by accident, so your lawyer has to be careful. But anyway, there does have to be personal jurisdiction there, unless we're dealing with some kind of property. And there's another situation that's called in rem jurisdiction, and that's another Latin phrase. We really don't care what it means, but it's dealing with property. And so let's say that you inherit a boathouse or something in Delaware, and you've never been to Delaware. But somebody else thinks it ought to be their boathouse, and so they sue you. Well, and you say, well, I've never been to Delaware. They have no personal jurisdiction over me. Well, they don't have maybe personal jurisdiction over you, but they have jurisdiction over your property. So if you want to keep that property, you jolly well better get to Delaware and start litigating, because they may have jurisdiction over the property, even if they don't have jurisdiction over the person. And so in cases dealing with property claims, then they don't have to have personal jurisdiction over you, as long as the property's in that state, and they have jurisdiction over that. All right, well, we're done with jurisdiction for the moment, at least. Let's move on to venue. And at this point, you're probably thinking, oh my goodness, I had no idea it was such a complicated matter, trying to figure out what court you belonged in, and all this jurisdiction, these different kinds of things floating around, and all this is horrible. Well, it is horrible, but we're not quite done yet. There's one more thing called venue that we need to look at. And interestingly enough, even if a court has jurisdiction, it may not be the best place to hear that case. Let's take, for example, our car wreck again. It happens on the boulevard in Neosho. It happens between two Missouri residents, let's say. One lives in Granby, one lives in Neosho. So they're both local residents. They had this car wreck. There's a lawsuit. But for whatever reason, one of them decides to go up to northeast Missouri and file the lawsuit in Kirksville. Okay. Why they would do that, no one knows. But let's say that they do that. Okay. Well, the circuit court in Kirksville, do they have subject matter jurisdiction over the case? Can they hear a car wreck case that happened in Missouri? Absolutely. No problem. Do they have personal jurisdiction? It's a Missouri court. We're dealing with 2 Missouri residents. The accident happened in Missouri. Absolutely. They have personal jurisdiction. So they have subject matter, they have personal jurisdiction. Constitutionally, there's no reason that the court in Kirksville shouldn't be able to hear that case. But does it make any sense at all to be up there in Kirksville, which is, like a 4 or 5 hour drive away from here, hearing a case that happened in Neosho when there is a courthouse on the Neosho Square, 20 yards away that could have heard this case? No. And so to prevent situations like that from happening, states have passed statutes dealing with venue. And even if your court has jurisdiction over the case, venue may be improper. And if one of the parties raises a venue question, that may force the court to transfer the case to another circuit, within the state, if that is where the venue statutes say that the case ought to be. And this is all defined by statute. The state of Missouri, the legislature has passed laws defining venue and which court should hear which kind of case. And so that's all determined by statute. We just have to go to the venue statutes and see. And again, if the wreck happened in Newton County and the residents are both in Newton County, that's pretty much a no-brainer. But sometimes we'll have more complicated factual scenarios where one person lives in one county, the other person lives in another county, and the accident happened in a third county. Well, where do we go? Well, we go to the venue statutes and figure that out. So anyway, that's what we do. And once in a while, you'll hear about a change of venue in a criminal case. And that's a situation normally where there was a criminal case with a whole lot of publicity, and the defendant thinks he can't get a fair trial in the county that he's in, and so he'll ask for a change of venue. Well, that just means that we want to go to a different court that has jurisdiction, but we want a different venue that's far away from where all this publicity happened or something. So now you know what that means. The different courts may have jurisdiction, but venue may be proper in one court, but we want to get it out of that court, but in another court anyway, and there are rules that are defined by statute where that can happen. So, and that can sometimes happen in a civil case too, but we normally hear about that in criminal cases. All right, well, let's talk about what actually happens in these courts that we've been looking at. What is the process of litigation? And that's where one person is suing another. Okay. Well, in our United States and in basically anywhere that's descended from the mother country of Great Britain, we have what is called an adversarial system. And that means that we have 2 sides that are arguing about a case. And what they do is you have one side that puts on the best case they possibly can, the most persuasive arguments that they can come up with. We have the other side that tries to shoot down those arguments and put up the best arguments they can come up with. And then we have somebody who's sitting there impartially listening to all this and figures out who the winner is. That's an adversarial system. And it really is based upon a healthy competition of views. It doesn't work if we don't have both sides ably represented by legal counsel. And that's why in a criminal case, a defendant has a right to an attorney, because it's really not fair if we have a professional prosecutor who went to law school up against Joe Schmuck who didn't make it through high school. The adversarial system breaks down because we need, in order for justice to be done, our system depends upon really good arguments being made by both sides, the best case being put forward that they can make. And so then the judge basically in that case is just refereeing the case, and eventually the judge or the jury, if there is one, will decide who had the better arguments. Okay. Other countries, briefly, I'll mention, just have a different type of system called an inquisitorial system, like France or Spain or somewhere like that descended from Roman institutions and that sort of thing. In that case, the judge is actually a lot more active in it. Here, our judge is basically just a referee. There, the judge is really trying to do a lot of work trying to figure out what the facts of the case actually are. The judge will be asking questions. The judge will be doing that stuff. And you've seen enough court on TV probably, or court shows or whatever, that the judge just sits up there and says overruled or sustained or whatever most of the time, just listens to what's going on in our system. That's not the case in other countries. Just know that that's different depending on what country you're in. But we depend upon the adversarial system. And again, the judge is the referee, and we talked about he'll make rulings of law and maybe findings of fact, or the jury will do that if it's a jury tried case. And not all cases will have a jury. But some of them do. Some cases for whatever reason, we may want the judge to make the findings of fact if it's a really complicated case, or we think the jury would be unfair or something, and sometimes that happens. But anyway, that's what we have going on. The judge and or the jury just listening to the arguments of both sides, trying to figure out who has the better arguments. After the findings of fact are made and we figure out who wins, basically the court will enter a judgment declaring who wins and how much money is changing hands, maybe, or whatever the case is in that particular court case. All right, well, let's talk about the actual steps you go through in litigation. The first step is the pleadings. And when you're going to sue somebody, you draw up a document, and most jurisdictions call it a complaint. Missouri, for whatever reason, calls it a petition, stating what you think is entitling you to a judgment, what the other person did wrong, blah, 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 and I want this amount of money, for instance. And then you have that person served, that's send the sheriff deputy out to go do that, or a process server or whatever. And then once the other person is served, they all have to file an answer, saying admitting or denying what's in the petition or the complaint. And that's the pleading stage, and that's how cases get started. Here's an example petition. If you want to, you can pause the slideshow and just kind of look at it. It's also contained in the lecture notes for this unit. I just kind of threw this together. I used to be an ambulance chasing attorney who did car wrecks, and so I just kind of threw together this fake petition just to kind of show you what it would look like if you sued someone based upon a traffic accident, just to kind of give you an idea of what a Missouri, anyway, petition looks like. And we just set out who the parties are, the facts of what went wrong, and why we think we're entitled to something based upon that. In this case, it's a negligence claim that somebody was a bad driver, and we want damages, so the court should award us damages. And that's really what a petition is. And in the answer, the defendant would have to go through and respond to each one of these paragraphs and admit it or deny it, and then might add on some other things to the end. But this is how a case gets started. Okay, well, the process of litigation, we talked about the petition gets served on the defendant. The defendant then files an answer. Once in a while, a defendant won't bother to file an answer. You never, ever, ever want to do that, because what happens is there's a certain amount of time you have in which to file your answer. If you don't do that, the plaintiff will go to the judge and say, look, judge, the defendant didn't even bother to show up in court. They were properly served, and therefore I should win by default. And the judge will probably say, okay, and enter a judgment against the defendant. So if you are ever served with papers, by golly, if you don't know what to do about it, get your attorney and find out what to do about it, because you don't want to ignore something like that, because you could get in big trouble. There are ways to set aside default judgments and proceed with the case even if you messed up, but you don't want to be in that situation. So anyway, just know that that can happen. So once the petition has been filed, the defendant has answered, things may get more complicated from there. Pleadings can get very tedious because you may have something called a counterclaim, which normally the plaintiff is claiming that the defendant did something wrong, but once the defendant is served, the defendant can file an answer and a counterclaim wherein he says, but look, the plaintiff did something wrong too. And then the plaintiff has to answer that counterclaim, and they're pointing the finger at each other, and things get fairly complicated. Sometimes you can have a cross-claim, and that happens where you have multiple defendants, let's say, and let's say there's 3 defendants, and 2 of them are claiming the third one is at fault, that they're not, that it's the third guy's fault, so they'll file a cross-claim. So that happens when you have like plaintiffs pointing at each other or defendants pointing at each other or whatever on the same side of the case. And anyway, things get really messy sometimes. Also, you've probably heard of the statute of limitations. This is a very important thing to remember, that you don't have forever in which to file a lawsuit. I used to be an ambulance chasing attorney and do car wrecks and that kind of thing. And in Missouri, anyway, used to be the what it is now, I haven't kept up, but the statute of limitations for a car wreck used to be 5 years. So if you got into a car wreck, you had 5 years to file a lawsuit against the defendant who hit you. But different cases have different statutes of limitations. For instance, if you had a medical malpractice case and the doctor cut off the wrong leg in surgery or something, and you were suing the doctor, then you only had 2 years, let's say. So different cases can have different statutes of limitations. And what that does is it creates a level of fairness, because you don't want to be sued based upon something you allegedly did 30 or 40 years ago. It's hard to defend a case like that because you probably shredded all the papers a long time ago. The witnesses have died. You don't know. You can't find the evidence that you need to defend yourself. It's unfair. And so what the law does is just create these arbitrary cutoffs that beyond a certain amount of time, doesn't matter how good your case is, if you don't file it on time, you'll never be able to file it at all. And so that's how They kind of cut that off. And so if you have a wonderful case, the best case in the world, and you file that case one day after the statute of limitations runs out, your case will be dismissed and you will never recover anything. So it's important, if you have a claim, to know what the statute of limitations is, because that sets up the amount of time in which you have something to do, time to do something about that case. So very, very important. Okay. Well, after the pleadings are all pled, then we may have motions. And a motion is just where one party is asking the court to do something. Some common examples, we'll have a motion to dismiss sometimes. And defendants commonly file this, and that's basically telling the court, look, court, even if everything that the plaintiff said is true, they still shouldn't win under the law. Here's why you should dismiss this case. For instance, if the plaintiff filed after the statute of limitations ran out, the defendant would file a motion to dismiss based upon the statute of limitations. So asking the court to throw out the case, and those are pretty common. Usually they don't work, but they always try. And then there's motion for judgment on the pleadings, which, again, asking the court to look at, the pleadings and say, look, court, if everything that's been said is true, then they don't have a case and you should throw this out and not go on. So just another example of a type of motion that you might have. Once discovery is complete, we'll look more at discovery in a second, there will be a motion for summary judgment a lot of the time, and asking the court, saying, look, court, here's all the evidence. We've gathered all the evidence in this case. It doesn't need to go to a jury because it is so stinking obvious what happened and who should win. We shouldn't even have to bother with a trial. And asking the court to make a judgment on the case right then and there. So different kinds of motions that we'll have, and then during trial we'll have motions to exclude evidence and all kinds of stuff like that. So that's what motions are. All right, well, once we've had the pleadings and we've had some initial motions, probably we'll get to the discovery stage of a lawsuit. In the discovery stage, we're trying to find out what the evidence actually is. And the law gives us tools in which to discover what the facts are. Several different tools are available, one of which is interrogatories. These are written questions that you can serve on the other party, demanding that they answer these under oath, by the way. And so you can find out all kinds of interesting things. Have you been convicted anywhere? Have any crime before? Have you ever had any other accidents? Where did you get your car worked on before your brakes failed? All kinds of stuff you can do in written question form in interrogatories. And usually these are actually filed along with the pleadings. The plaintiff will send some initial interrogatories to the defendant. And so that's one way that the law gives us to find out what the evidence actually is in a case. Also, we have what's called a request for production of documents. So let's say that you had a car wreck case where the brakes failed on a car and you wanted the maintenance records of that car. And so you would ask them to produce receipts from anywhere that they had their car worked on in the last 5 years. And they'll have to cough up these documents. And you might ask for their insurance policy, to see how much coverage they have and how big your recovery is likely to be. So we can ask the other party to produce documents. We can also conduct depositions, and this you may be familiar with, but it's kind of like questioning in a court of law during a trial, but this usually takes place in a lawyer's office with a court reporter, and we'll put somebody under oath and ask them questions about a case. And it may be one of the parties, it may be a witness, or even an expert witness or something like that, but we'll have this deposition where both parties get to ask questions of whomever they're deposing. And so this is another way that we can gather evidence. We also have something called a request for admissions. And so we can, usually these don't work as well as we would think because the other side will argue about them, but we can send, let's say, a request for admission to the defendant in our car wreck case and say, we request that you admit that you were drunk when you were driving your car on such and such day. And, they may have to admit something that they don't want to admit. And so that's another way that we can do discovery. And keep in mind, throughout this process, there will be objections and the court will have to rule on these things. And this isn't, we don't give the parties free rein here. If they're asking about something that has nothing to do with the case, and the court will put a lid on that and tell them to stop it. But if the questions that they're asking are fair, and they actually have something to do with the case, and then we give the parties these tools to find out what the facts are before we ever get to the trial stage. And so by the time we finally get to a trial, we'll know what's going on in the case. And for that reason, the Perry Mason moment is a myth. And I may be dating myself a little bit. Perry Mason was around long before I was even. But if you've ever seen these old Perry Mason movies and stuff, He's a famous lawyer, or Matlock, if you're more familiar with Matlock. Usually the way this would happen, we'd have this case, and it was kind of a pseudo mystery, and would end up in court, and at the very end, someone would break down on the witness stand and admit to committing the crime, and everyone would gasp in the courtroom, and it'd be, oh my goodness. Well, that's all a bunch of crap. It never really happens. Rarely are there surprises at a trial because we've had the discovery process. By the time we get to a trial, both sides know what the facts of the case are. They know what all the evidence is. They have been through it. They have deposed people. They have sent interrogatories. They've looked at documents that were requested. All this kind of stuff. They know what the facts are. So very rarely do we ever have that dramatic moment in the courtroom where something is revealed or somebody's exposed as the real killer or whatever. That's just TV. So anyway, most law is much more boring than that. We have the discovery process, which takes out the mystery. So, and that's very actually handy because we don't want mysteries at trial. We want to be able to prepare properly so we can present the best possible case that we can. Okay, so we've been through the discovery process. We've done all the motions and pleadings and stuff. We finally get to the trial itself. And you've probably seen some of this on TV, so you have some idea how this works. We have our opening statements. Both sides will kind of introduce the jury usually to their arguments, their side of the case. Both lawyers will get up and do that. Then we'll put on the plaintiff, or we'll put on the case in chief, which is put out all the evidence that they can supporting their arguments, their side of the case. And once they rest, then the other side will get to put on their case in chief. And we'll get to do a rebuttal. Once the defense has put on their case, the plaintiff side can do a rebuttal to kind of debunk the stuff that the plaintiff said. So that's just a matter of putting on evidence. It's calling witnesses. It's playing depositions sometimes, showing physical evidence maybe, pictures of the scene of the accident or whatever, calling expert witnesses to explain all the physics involved in a car wreck if we're dealing with our car wreck case, that kind of thing. Once the case in chief and the rebuttal case is all over, both sides will rest. Then we have the closing argument where both sides will get a chance to kind of sum up their case and say, remember what I told you in opening statement? Well, you saw this evidence, and this evidence, and this is why I'm right, and the other guy is wrong, and he's full of crap, and it's obvious, and you should decide for me. And then, so that's what they will do. They'll argue to the jury, and then both sides will work out jury instructions with the judge, and these written instructions will tell the jury exactly what they need to decide and give them a form to fill out on who wins and maybe how much money they are going to award or whatever. And then the jury will go back and talk about it, deliberate, examine the evidence, argue, whatever, come up with a verdict. And they will issue their verdict. Should mention that we're used to unanimous verdicts in criminal cases. Usually, is what we see on the news and stuff. In a civil case, you don't have to have all the jury members agree necessarily. Different states do this different ways, but sometimes just a majority of the jury is all you need in a civil case. So you don't have to be a unanimous verdict or something. We're not sending someone to the electric chair in a civil case. We're just awarding money on a contract or something. So the burden's a little bit less. But anyway, so that's what happens there. And then once the jury comes back with a verdict, the judge will enter a judgment, and then the trial court's done, and maybe one side will want to appeal, maybe they won't. But anyway, that's what the litigation process looks like at the trial court level. One thing that I want to mention before we go too much further is the burden of proof. And this is different in criminal and civil cases, and that's important to realize. And most people don't realize this, and it's very important. It's one of the things that civil attorneys have the hardest problem explaining to juries, is that they don't have to be absolutely sure to decide a case. In a criminal case, we know that in order to find someone guilty, you have to have proof beyond a reasonable doubt. We've heard that phrase before. What we should be thinking about in that case is being 95% sure. We don't have to be 100% sure that someone is guilty in order to convict them, but we have to be pretty darn sure. We don't have to eliminate the evil twin hypothesis or, the remote possibility that aliens from Mars came down and committed the crime and not the defendant. And we can eliminate those crazy things, but we have to be pretty certain that they're guilty before we can convict them. So, like 95, 98%, we have to be really sure in a criminal case because we're taking away somebody's, maybe their life, but their freedom. We're sending them to jail. We're putting some horrible thing on their criminal history. We want to be really sure. And so that is what happens in a criminal case. We have to be sure beyond a reasonable doubt. Okay, well, a civil case is different. In a civil case, we're talking about money or we're talking about property. The stakes aren't as high, and so the burden of proof isn't as high either. And all we need in a civil case is a preponderance of the evidence, which means like 50.1 or 50.0001% sure, more than half. And so if you have the plaintiff and the defendant, and you're more likely to think that the plaintiff is right than the defendant, then the plaintiff wins. It doesn't have to be certain. It doesn't have to be beyond a reasonable doubt. You can have lots of doubt. But if you're at least more than half sure that one side is right than the other, then they've met their burden of proof. So if the plaintiff, makes you more sure than not sure, then you should decide for the plaintiff. And people don't like that because we want to be able to figure out what happened. We want to have definite answers in life. But that's not what the burden of proof is in civil litigation. It's just more sure than not. So a preponderance of the evidence is all we need. That's very important. And again, the civil standard bothers people. We like to be sure about stuff, but that's not how it works in a civil case. And my favorite example of this, it's getting kind of dated now, but is the O.J. case. And if you remember the O.J. Simpson murder trial, the jury let him go. They said that there was not proof beyond a reasonable doubt. Okay, so he got off on the murder charge. Okay, well then the family of the victims sued him, and they won. And so people are scratching their heads saying, okay, so one court said that he didn't do it, and the other court said he did do it. How does that work? Well, the answer to that is, in the criminal case, for whatever reason, the jury decided they didn't get to the beyond a reasonable doubt level. They weren't 95% sure. But a second jury came in and said, well, we're more than 50% sure that he did it. And so he lost the civil case, and the families were awarded a money judgment against him. And so you can see the two different standards working simultaneously with the same set of facts. That sometimes we can be 50% sure something happened, but we're not 95% sure. And so you kind of see those two different standards being applied to the same set of facts. So anyway, just know that a civil case has a totally different set of rules as far as burden of proof. Okay, well, let's look at the appeal process. And we've already looked at this when we looked at the appellate courts. But once we're done with the trial, we have the jury verdict, we have a judgment entered. If one party is unhappy with the result, they can file what's called a notice of appeal to the other side saying, hey, other side, you may have won, but it's not over yet. I'm going to take this to the Court of Appeals. And so they do that. Both sides will file briefs. They'll have to submit the record. The party that's appealing will have to submit the record on appeal, which they have to pay for all the transcripts to be printed up and stuff like that, and get all the exhibits ready and all that kind of stuff, and be sent to the Court of Appeals. Then both sides will write legal briefs that explain, one side will be saying the trial court screwed up and here's why. The other side will be saying, no, the trial court did not screw up and here's why. In written form, they'll send that. The Court of Appeals will read the briefs, and then they will schedule oral arguments to where the attorneys for both sides will show up, and they will try to present their case in front of the Court of Appeals, and then they'll try to answer any questions that the judges may have. And that involves thinking on your feet. It's not an easy thing to do, and so a lot of lawyers get very nervous about that because judges can ask pretty hard questions sometimes. But those oral arguments will take place, and as we already saw, the appeals court can agree with the trial court and affirm it. They can disagree with the trial court and reverse the case, and either way, they'll probably remand the case back to the trial court with instructions saying, okay, here's what you did right, here's what you did wrong, here's what you need to do now. When an appeals court or a Supreme Court hears a case like this, they will issue an opinion. And usually there's no written opinion at the circuit court level in the state. Federal district courts will issue opinions, but if we're reading a case opinion like you'll see scattered throughout our textbook, that's coming out of a court of appeals. And we'll have several different opinions. And once they've heard the case, they've made up their mind about it, they'll take a vote, who won, and the majority of the justices will agree, this side wins. And then one of those justices will write a majority opinion. And the majority opinion is the law. That's the law of this case. It'll apply to this case, but it also has precedential value. Remember that we talked last week about the value of precedent and stare decisis. Well, this is where we get these. This is where the common law is made, is when these cases are heard on appeal. And so a case will be heard, the majority will decide, they'll write an opinion, and then we have that opinion published, and attorneys can get that and know what the law is in a particular case like this, and they can use that in their case and say, look, this court decided this way. This is how you should decide my case. So this is where we get the common law, is through these court opinions that are written. Sometimes we'll have other opinions besides the majority opinion. Sometimes we'll have a concurring opinion. And this will happen a lot of times at the Supreme Court. You'll see this happen where a justice will agree with the result of the case, but not the way they reached that result. And so he'll say, okay, majority, you got it right, but you got it right for the wrong reason. Here's why you should have gotten it right. And so he'll write a concurring opinion explaining his alternate reasoning. Sometimes you'll have the judges who are on the losing side write an opinion. That's a dissenting opinion. They will disagree with the majority opinion, and they will explain why. And you might ask yourself, okay, well, they lost. Why are they going to put this out there? Well, sometimes they feel really strongly that they were right and the other side was wrong. And once in a while, even with our stare decisis and everything and our value of precedent, courts will get overruled. And sometimes we'll have the reasoning, the dissenting opinion will become more persuasive over time. And, if a case like this comes up, in 20 years, the court might look at the majority opinion and then read the dissenting opinion and say, I think the dissent had it right on this. And so they'll go ahead and reverse the case. And so sometimes those, the legal theories put forth in dissenting opinions will actually become the majority view later on. And so they also have some value too. So sometimes those get written. All right, well, after looking at litigation, one more topic we're going to cover very quickly is alternative dispute resolution. And in the modern world, sometimes we like to stay out of court. And you can see why after we've looked at the process. It's long, it's involved, it's messy, it's expensive if you're paying attorneys to do this. And so if we can resolve a dispute without actually going through all this process, sometimes we'll want to do that for several different reasons. One way is it's faster. The total time from filing a lawsuit to having a trial and going up on appeal and all that can take years. And so if there's a faster way to handle these disputes, that might be a good thing. Also, it's more private. If you file a lawsuit in a state or federal court, that is public record. The newspaper can get in there and get the case file and find out who's accusing who of what. And so that can be embarrassing sometimes. So if we can stay out of there, that might be beneficial to us. Also, the expense. Litigation is not cheap. You're paying attorneys by the hour a lot of the time, or if you're a plaintiff, like in a car wreck case or something, you're giving the attorney 30 or 40% of whatever money you get. That's going to be expensive. And so attorneys are not cheap, so if we can use them as little as possible, that will help. And so there are other ways of doing things. A traditional way to avoid a trial, at least, is a settlement. And probably, I don't know what the figures are, but a majority anyway of civil cases probably are settled. And that's where one side agrees to pay money in exchange for a release of liability. And the thing to know about a settlement is it's not an admission of fault usually. So let's say that we have our classic car wreck case that we're talking about. The plaintiff sues the defendant, and they could go through this whole process of going to trial and picking a jury and all that business, and that'll take a long time and cost money and everything else. And it could be the defendant, is adamant that they're not at fault. They really don't think that they did anything wrong, but, they don't want to go through this whole process and give up, have this hanging over their head for a couple of years and pay all this money and all this kind of stuff. So they'll just settle the case and say, hey, plaintiff, would you take this amount of money in exchange for signing a document called a release that lets me off the hook? That means you can never come back and sue me on this again. And usually the defendant won't admit fault, but the plaintiff will look at that and say, okay, well, I might be able to go to trial and get a certain amount of money, but it might be better off if I just take this amount of money now, avoid all the time and expense, and call it a day. And so settlements happen quite a bit. And sometimes they'll happen before a case is even filed. Sometimes they will happen during litigation, during the discovery process or something. Sometimes they'll happen at trial. Sometimes, a defendant will, get to trial and see how horrible their case looks in front of the jury, and so they'll settle real quickly. Sometimes it'll go up on appeal and settle on appeal. So it can really happen at any point in time. This isn't really avoid litigation, but it cuts it short. And so we're including it here, talking about settlements. An actual way to avoid, perhaps, getting to court at all is through mediation. Sometimes mediation will occur during litigation. Sometimes it'll occur before litigation actually takes place. Sometimes different sides will get kind of, stuck in a rut and hard-headed about things. And Sometimes it helps to bring in a third party who's objective, probably like a retired judge or an experienced attorney or something like that, that'll kind of work with both sides and help them come to a settlement. And so, both sides may present their cases before a mediator. The mediator will look at that, and the mediator may say, hey, plaintiff, you're really asking for too much money. And hey, defendant, you really were at fault and you don't look good in this case. You should probably think about settling. And it'll help the two sides kind of come to an agreement. And sometimes that third party kind of helps diffuse a situation if the plaintiff and defendant are kind of at each other's throats, and kind of help them see the case objectively. So that's what mediation is. The mediator doesn't have any power to force them into a settlement, but can kind of help them reach one on their own. Then we have binding arbitration. And if I'm not mistaken, our discussion question has something to do with that this week. Binding arbitration avoids the litigation process altogether by basically having a private dispute resolution set up where we hire somebody to be an arbitrator. An arbitrator is just like a private judge. So again, a retired judge, an attorney, somebody like that will hear both sides' case and then issue a ruling, and that's not appealable. That's it. And we'll avoid the whole court system entirely. The arbitrator will make the decision and both parties will just live with it. And one party may pay the other money or whatever the case is. But that's what we'll do. And sometimes that saves a ton of time, and sometimes it can save money, and it's very private. Sometimes it doesn't save money. So oddly enough, it can be more expensive to go to arbitration than it can be for a regular old plaintiff to just get an attorney on a contingency fee and go have a normal case. And so again, our discussion question kind of touches on that. So anyway, there are ways to get out of court. These are more popular all the time because court is a big mess, sometimes expensive and out in public, and if we can avoid it, sometimes it's a good thing to do that. So all right, we've made it through the notes for week 2. So have a good week. Talk to you next week.